really unique to the UK as a custom.
Yeah. I mean, basically, what's our custom? I would say our custom has been to let politicians lie and screw us over and steal from us.
Yep.
I would say that's a custom. You know, so let's change just that custom. Wouldn't that be a good thing? Okay, and the other document we rely on is the Coronation Oath Act 1688. Okay? This here, when it's spoken, creates the binding contract. Okay? The Bill of Rights says nothing can be done to the prejudice of the people, and they have the obligation to ensure that the government does what Parliament says. There cannot be ecclesiastical courts. What's the substance of that there? The substance is those governing must ensure there are no courts based on belief systems. Okay? It doesn't matter if it's a religious belief, because the substance is, it can be a philosophical belief. And then everybody has the right to freedom of speech, everybody has the right to bear arms, everybody has the right to trial before fines and forfeitures, and then they've got this nonsense about you have the right to vote and crap like that. That's all rubbish, okay? Because it's the law, that's where we individually can be represented. So, we're looking at why is legislation not law? The first
You
verse
spelled
says...
Parliament wrong. You spelled Parliament wrong.
Yeah, no, it's a quote, okay?
Oh.
Old English.
Oh, right.
But thanks, yeah. So the first oath says, statutes in Parliament agreed upon, which today we call primary legislation, okay, is one constraint. It continues the law, because it's got the word and between, is another constraint on authority, and then again it's got the word and customs. So therefore, they themselves admit in their document, the Coronation Oath Act, statutes in Parliament or legislation is one constraint on them governing. And that day we know in the Bill of Rights, because Parliament is the principal and the government is the agent, they can't do anything without the authority of Parliament. The next constraint is the law, and the next constraint is customs. So there's three things by their own admission there.
But what constraint is customs when we don't know what it is?
Yeah, doesn't matter. We can sit and argue about the definition. But there's, in their own writing, black and white, judicial notice must be taken. You guys, in your own rule book, your game, you've said legislation is not law. Okay? And then when we go to the Act of Settlement, it actually in section 4 gives Parliament's own legal definition. In legislation they say the law is your birthright. Again, confirming legislation is not law, and actually saying the law, when we use the word the law, it means your birthright. Okay? So we've got a definition of the word law. This is how I got onto the Boris Johnson judgment, because I was trying to look for these definitions of legislation, law, statute law. They use everything totally intertwined. So finally, we can hold them to account to this definition. It's only been around for 300 years.
Can I just...
Yeah.
Paul, actually, the point that you brought out there on customs, it makes it even bigger, because you can go and stand, my custom is...
Correct.
Well, that's
So
what I'm
it's
saying.
viable.
How many? Is there a number that has to be together to be a custom? I mean, can we all make a
I don't
custom
know.
here
It's
today?
individual, it's you, your custom.
Yeah. Yeah.
But
again, it
which
comes-
one are they? I mean, if it's a constraint, what constraint is it on them?
Well, that if it's your custom to do what you want to do,
So long as you
they
don't
are
know
bound
what-
by it.
Yeah.
Do you think the Muslims have saying that that's our custom? Because they can start.
Yeah, absolutely.
Yeah,
I think so.
Nice, can't they?
Yeah, I mean, basically, if that community wants to have a mosque there, so long as it doesn't affect the community somewhere here and they want a church, let them have their mosque and you have your church. What's the problem? So long as one does not impose its will on the other. Do what you like, follow your conscience.
It's so true because they, you know, what do they call the ones that wear the Sikhs, that wear the big...
Yes, they
Yeah.
carry knives, don't they?
Yeah, so they, not only can they carry knives, but they can ride a
They
motorcycle.
don't have to wear a
without
helmet.
You know, so that's not...
So could it be a defence, just saying, well, it's just not the custom, sorry.
Well, I mean, you'd have to sit and argue it, and have support for it. And you'd be able to show that it's a custom, i.e. your actions need
Go
to
back in
support. You can't just now today change your custom and claim that you've been like this the whole time.
You can't have a custom that's against the law, can you? Because you're
No,
still
you
covered
can't.
by laws
You can't.
separately from
You
custom.
can't, right. Okay, so the second promise of the Coronation Oath Act, like we said yesterday, creates the independent judiciary. Okay? And that there is only according to law. There's no customs in that. Okay, so in the courts we don't sit and argue customs. Now, we looked at Betty Boothroyd's thing, and we'll reinforce what she said. Okay, but basically, Edward Coke, William Blackstone and Dicey had this concept of parliamentary sovereignty. Okay, this is where all the bullshit came in, with Parliament thinking it can tell us what to do. Yeah, Nick?
They're only doing that to rebel against miscreant kings and queens, wasn't it?
The whole,
That was the
exactly.
whole point behind it.
Now, if you look at what was the intent behind the Bill of Rights, it was to control the tyranny of rulers. Okay?
Absolutely.
That was the intent. All that's happened is the king was the tyrant and now Parliament is the tyrant. Okay? So the substance behind the Bill of Rights is what people have forgotten and Parliament's forgotten it. Okay?
Do you remember about when this happened?
Well,
We weren't around.
Coke was 1600, wasn't it, something like that?
Before the Bill of Rights.
So,
No, post Bill of Rights. Yeah. But basically, it's a concept, it's a theory, which is not borne out in fact of evidence by their own admissions. Yes.
At the same time, Edward Coke said in the Dr. Bonham's case, he said, an act of Parliament is against common right or reasonable repugnant or
Correct.
would be formed
Correct.
common law will control such actions and judge it to be void.
Okay.
So he's saying common law is superior to Parliament. Even
Correct.
though He's got a doctrine of Parliament.
Yeah, but the difference, what I'm saying is, okay, the courts did not create the Act of Parliament. The courts have authority to say it's unlawful, but they can't uncreate it. Only Parliament can uncreate it, because they were the creators. And equally, it applies the other way around.
I disagree.
Parliament cannot uncreate. It adds a constraint, and basically the Act of Parliament is unlawful. It has no lawful authority. Okay, it may still exist, but it's not lawful. Okay, and this is why we need to distinguish between legal and lawful. Lawful is a constraint on Parliament by their own admission, as is on the government, as is acts of Parliament. All of these things, what we create in the courts is the unwritten constitution, which controls Parliament, because one of their obligations is to act lawfully. And the second thing is, the acts of Parliament that it creates also puts a constraint on.
As you said yesterday, rightfully so, exactly what you're mentioning now, is that the MPs at the moment want to make it that they can choose, pick and choose
Yeah.
which court outcomes they want to do. And they can't do that, because obviously that's the
No,
rule
they
of
can
law.
do that. They can enact whatever they like. Okay, if you want to be somebody's sex bitch, mate, you can do it. Okay, if you want to go and get beaten up in a boxing ring, you can do it. You can consent to it. But it's that consent which creates the lawfulness of it.
What I mean is they can't overrule the courts.
You saying
As
they,
They are, as the
they can
courts
do
can't
what
overrule whatever
they can
want
do
to
what they like, just like each of us can do what we like.
you're talking about...
However, they
pick and
can't
choose which
enforce
ones
it.
they-
Yeah.
They can't enforce it on anybody else. Okay? So they can do what they like. It's got nothing to do with us.
They can't pick and choose which judgments they're going to...
They-
Which is what I think that's what...
Yeah, no, okay, but this is why, again, going back to the Commission of the Metropolis versus Rising 2008, before any individual follows an order, doesn't matter who the order's from, even if it's from the court, okay, if that order is unlawful, and you act on it, you're personally liable for it. Why? Because you have a duty of care not to knowingly cause another harm. It all comes back to breach of peace. You've got to apply the best available knowledge, and blaming somebody else ain't a problem. Ain't going to get you off the hook. Okay, so now, even recently, and so again I want to reinforce this, we went through it yesterday, the Bill of Rights is a constitutional statute. What does that mean? This is what created the fiction of law, creates the authority. Therefore, Parliament cannot uncreate that, because that's what created it. Okay? So they can't change the Bill of Rights, they can't change constitutional documents. Right? And so this was the Metric Martyrs case, the special status of statutes, constitutional document, example, Bill of Rights.
So just quickly cut in. So the Magna Carta though, you know, they claim that that's been repealed and, you know, uncreated.
You're talking about Magna Carta 1215?
Yeah.
Yeah, well, I was King John I, was it? Okay, I created Magna Carta, I died, Magna Carta disappeared with me.
But wasn't that an agreement though between
The barons,
yeah,
that was the barons and the king,
right.
okay? Nothing to do with the people. It was a contract between the barons and the king,
It was, yeah.
okay?
Wasn't it also, Mark, that there's the issue of him being forced?
Another issue,
Yeah.
nobody knows, okay? But it doesn't matter, because John created it, and he died, and it died with him.
Yeah.
Then, was it Henry III or the pageant king, whatever it was, picked and cherry-picked, they left out Article 61, but they kept Article 29, the right of trial by jury. So the next king cherry-picks what they want to bring in to start their reign with, and then when that king dies, all of that law dies. The next king then selects and cherry-picks, reaffirms the charters, goes along. That stopped in 1688, when Parliament became the legislative body. The fiction, and that fiction is still alive today. Okay, so the important thing with the Bill of Rights really is the Metric Martyrs case brought out this distinction between the creating authority, the Constitution, the written Constitution, and that was reaffirmed by the House of Lords in 2002. Now, what I've added in on this section is this thing called prerogative power. Okay, remember we said the first promise, there's a claim which nobody's challenged, that the Archbishop is God's representative on earth and has authority to offer the contract to government. Okay, it's just an unrebutted claim. And basically, the Crown is the trust account, is the Crown, and the prerogative powers are the trustee role, the authority of the trustee. Okay, so the prerogative power, when they talk about prerogative power, it's as trustee, what authority do you have? So, Archbishop says, will you do promise to govern? There you go, there's a prerogative power. Okay, but basically, what happens is, and this I think is where the misinterpretation comes about parliamentary sovereignty. Okay? So this here, it's referenced where have I got it from. The supremacy of statute law. Where there is a conflict between the prerogative and statute, statute prevails. And this is where I think these guys think that they're supreme. They're only supreme over prerogative. Who's got the prerogative? The government, the executive. So, statute can constrain the government. That's exactly what the Bill of Rights says, exactly what it's saying there. Okay? So when we look at the evidence everywhere, okay, there is not the separation of powers that they tell you about the executive and the legislative. So there were two judgments where the court looked through the history. you're familiar with the one that I've been using a huge amount is the Boris Johnson judgment in 29, which says exactly the same thing. So in 2019, 11 justices in the Supreme Court cannot be overturned unless they increase the number of justices in the Supreme Court. They reintroduced the rule of law. Okay? Now, in the Article 50 activation, okay, somebody put that up in the group the other day, and I've actually started to read it. Read section 32, 33, and 34. It's all in there. Again, exactly what the Bill of Rights has set out. People, Parliament, government. That's the chain of authority. We tell them what to do. They don't tell us what to do.
He says, read Article
32, 33, and 34.
Of what?
Of the Article 50. Okay, what the argument was about, Parliament was saying only they can authorise triggering Article 50 in accordance with the European Union Act 72.
These paragraphs of the judgment.
Yeah,
Yeah.
okay. Those are the critical ones. Okay, so let's just think about this logically and rationally. The European Union Act, who created it?
Unelected officials.
Hmm?
Unelected officials.
Who created the Act?
European Union.
Who created the Act?
Parliament.
Parliament.
No.
So, if Parliament created it, who's the boss of it?
They are.
Parliament. So, there you go, you could have saved a few £1 million in taxpayers' money. If Parliament created the Act, Parliament has authority over the Act. Therefore, Parliament must authorise triggering of Article 50. End of case. You know, 2 sentences. But these two are basically 2 rulings which the significance people still don't understand. These are reintroducing the rule of law, not only from the intellect and the universe, by accumulating the history of judgments, and they actually refer to no, they don't refer to Bonham's case. Bonham's case they try and avoid, but the case of proclamations is referred to in both of these. Okay, and that was the year before Bonham's case. And it's brought together all the knowledge of the constitutionality of the rule of law and what's the relationship. Both of these say that people are the boss. How do we know that? Because in the second one, Gina Miller and whatever the other one's name is, Cherry, okay, 2 little yous and me's took the Prime Minister and the Attorney General of Scotland to court. We've created the law that says, mate, this is the way it is. Not you, just because you're Prime Minister. This is how powerful we are.
Yeah, but Gina Miller, you know where she gets her money from.
It doesn't
We don't
bother
have
me.
that money.
The point is, it's a you or I. Okay, the first PCP, I signed Matt Hancock's arrest warrant. Yeah, we fucked up, but so what? You or I have the power. Okay, what's Calvin doing? Okay, judges, the whole lot. Okay, we have the power. And it's through the law that we create, we enforce and hold them to account.
So basically, Mark, we've just got to get skilled as the creator in controlling that tyrannous
Correct.
parliament.
Correct.
and putting
We've
them in-
always had the power.
Yeah.
Okay, but our custom has been to, I'm too busy doing this, you know.
That's our custom.
It's our own fault.
That's our custom.
But it is also, but it also comes out of trust, the desire to trust.
Correct.
Yeah. Look at your iPhone. Look at your iPad.
Exactly. Okay.
Forget about it.
So-
Get out of it.
So basically, we've been through this yesterday. The king hath no prerogative, but which the law of the land allowing, from 1611, Case of Proclamations. The limits of the prerogative powers to govern were set by law and determined in the courts. By who? We, the people. Okay? And then the government, the agents of Parliament, are accountable to who? The principal, to Parliament, for what they do and in regards to efficiency and policy. And guess what? Who judges that? Parliament. Are you working hard enough? Are you putting enough hours in? Are you doing what we asked you to do? Are you doing what we authorised you to do? Okay? Nothing to do with the courts, it's an internal argument. However, if there's an argument between the two and the dispute can't be resolved, that then needs to go to public dispute resolution. And guess what? They are responsible to a court of justice for the lawfulness of what they're doing. So if it's not clear, the duties, rights and obligations, they need to go to the court to resolve the respective duties, rights and obligations. And of that, only the court is the judge. This is settled 400 years ago, still we've got this crap.
So who are the two parties in that case? Who are the two parties in court? That'll be the government.
So this one was,
Parliament.
hang on, whoops, hang on, this, I think this was another Diplock case. So this was the Federation of Self-Employed versus the people. So Inland Revenue Commissioner was one side, some individual is whoever.
Now I'm going back to Parliament assembled.
Yeah.
Okay. They are. What they're doing is not right.
Yeah.
Okay. So it's the. I'm trying to confirm that it's the people.
Yeah. Who
In
bring
court
the case to
against
the court,
Parliament.
Against Parliament.
Now,
Against
who's going to do that on our behalf?
Us.
you, me. They don't bloody do it.
Isn't it the Queen or the King?
No, they are the way we are represented. Okay? Each individual person brings a claim against those governing. Okay, our right to petition the monarch.
They work for us.
They work for us. We are represented in Parliament through the monarch
Yeah.
with the law that we've created in the courts. And that's how we control Parliament. Okay? So basically, remember last year there was that £650 million PPE ruling about the way they dealt with the PPE is unlawful? Remember that one?
Yeah.
Okay? Why the hell did the Attorney General not go and lock those people up and take them to court? Or why did the CPS not do it? Why? Oh, because we're just accustomed to it. Oh, well, let them just steal another 650 million, just add that onto the, and increase our taxes and blah, blah, blah. Crazy.
Amongst themselves, right? Everyone's robbing everybody.
Correct. Okay? Right. So, basically, using the court's own rules of evidence, okay, if you, Parliament, believe you have authority and you can create duties, rights and obligations on me, guess what? You 650 people need to bring the Creator into the court under the court's rules of evidence to give first-hand cross-examinable testimony that any individual of you or you guys collectively can tell me as an individual or the people collectively what to do without their consent. All are equal under the law. Nobody's above the law. This is all self-evident. Okay? So, how on earth can 650 people tell them what to do? 67 million people what to do. There's nothing that supports the concept of parliamentary sovereignty. Okay? And there's shitloads more evidence to support this. I'm just giving you a few examples.
So Mark, how's there a simple or straightforward version to petition the monarch to do with them?
However you feel appropriate.
I reckon we should just give Calvin some money and let him throw a claim in.
Okay.
What are you up for, Calvin?
Right, I just want to go through this section and then we'll have a break. So, the social contract. What is a social contract? Everybody talks about a social contract. Law needs to be understandable. It needs to be communicated. Okay? And guess what? That happens through the oaths, affirmations, or attestations. That is the contract. Okay? So, the 1978 Oath Act at Section 4 affirms it doesn't matter if you're not sitting on a stone or you sign on the top of a piece of paper instead of the bottom of a piece of paper. what was your intent, okay, behind the oath, affirmation or attestation that you gave? Of course this makes sense. Why?
Well, hold on a minute.
Equity.
Maybe it wasn't her intent. That's why she did sign at the top.
Well, it makes
Intent
no
otherwise.
difference because her intent is verified by the actions. What she does behind her back, this little stuff's got nothing to do with what she showed us. This means nothing to us
She's bound.
Fraud.
But
because
maybe
there
she-
has not been a meeting of the mind and that's fraud.
Okay.
Okay? So, and
She's reptilian.
that there says he is bound by it if it has been administered in such a form and with such ceremonies as he may have declared to be binding. Okay? So that there is telling you, I don't care about the form. And nor do Parliament care about the form. What is the intent? Equity is substance over form. Okay? So this here is how simple it is. The oaths, affirmations and attestations are the social contract. From a judge I expect you to behave according to law. A policeman I expect you to behave according to law. From the Attorney General I expect you to ensure that the judiciary is independent. What that means is the judiciary doesn't do what Parliament says. It says what we, the people, have created in law. That's what they do. Okay, and we look at yesterday, any administrative thing where the mind is not applied, if you're the judge and you said you're going to act according to law, you don't do that. Breach of contract. Guess what? That's the basis of all of Calvin's claims. Breach of contract. My word is my bond. When I give my word and bond myself to duties, rights and obligations, that is a contract. And my God, aren't the oaths, affirmations or attestations simple? Can you understand them? That's the law. Therefore, ignorance of the law is no excuse. My word is my bond. Honour. I walk my talk. Good faith. I do not put my self-interest above anybody else's. Why? We're all equal under the law. Nobody's above the law. We're all equal to a fair, equal share of the Creator's creation. Clean hands. Everything is open, honest, transparent. Why? Otherwise there cannot be a meeting of minds equals fraud. I can't physically coerce you. That there is a crime against the person. Okay? So that's how simple this stuff is. Honour. My word is my bond. I walk my talk. Good faith. I do not put my self-interest above that of anybody else. And clean hands. I do everything openly, honestly, transparently. That's how simple it is.
You know, ignorance of the law is no excuse.
Yeah.
But it's impossible for anyone to know all of the case law. So
You don't need to know the case law, so long
that
as
is
you,
the law, isn't it?
so long as you act with honour, good faith and clean hands, because the rules of equity prevail over the common law.
No. Case law is law.
No. Equity prevails over the common law in the event of conflict. So it doesn't matter what the common law says, so long as I act with honour, good faith and clean hands, I've always got lawful excuse. Makes no difference. Yes, no?
Regarding case law,
Yeah?
it should be made according to law. You need to know the law. The law is broadly what Mark's talking about, the very simple essence of it. Case law is
Must be equitable.
produced according to those principles, so you just need to know the principles.
Yeah.
Correct.
And they will,
Exactly.
what you were saying earlier about they can produce any case law they like, and another lawyer will produce another piece, and they argue out between the case law.
Yeah.
Ideally, each case should be judged on its own merits.
Yeah, the facts need to be evaluated independently, but the law, always the fundamental three principles apply. Everything. If it doesn't meet honour, good faith or clean hands, there's something wrong. Okay? So, if you look at so many things that are going on, bad faith, unclean hands, okay? That's the problem. Now, how you want to, the form of word you want to use to describe that bad faith or unclean hands is irrelevant. So long as you can describe the harm, whether it's fraud or trespass or this or that or the other, that's form. It's irrelevant. Describe the harm. Okay? So we've got to get the simplicity so that you can start to quickly see where the problems are and focus in. And don't waste time down all of these nonsense rabbit holes, and the lawyers take you down creating dispute when none exists by making bullshit claims where they've got no right to make a claim. All of this is simple equity.
So once
Okay.
it's, so
Let's have a break.
once
Yeah.
it's bad faith, unclean hands. And
Bad faith is anything where somebody puts their personal interest above that of anybody else.
And unclean hands.
Unclean hands is if there's anything where I'm trying to fraud you into misrepresent something to you. I'm trying to commit a crime against you, your mind.
So once we show the harm,
Yeah. Once we show how we've been harmed because of either dishonour, somebody breached their word, breached their contract, their bond, or they've put their self-interest above that of anybody else, or me in particular, or they've in any way tried to misrepresent the truth. Those are the only three things it comes down to. What do we need for contract? We need advice. That means we need a meeting of the minds, and we need consent, which is the agreement to bind ourselves to the duties, rights and obligations. Everything is contract. Simple.
Not responding to notices is dishonourable, isn't it?
Correct. Bad faith. Why? They're either putting their personal interest above that of you, or they may be, by omission, fraudulently avoiding the truth. Okay. So the notices are really powerful things and fundamental. Okay, let's have a quick 10-minute break.
Hey!